Thanks for having me. Obviously, thanks to DigiShares and Ravencoin, Tron, and everybody, and Klaus. And so my name is Andrew Bull. I run a law firm in the United States that is specifically targeting blockchain and cryptocurrency. I started on the tech side originally, ran a mining company and investment fund. And really, we're trying to tackle the inconsistencies in federal and state regulation here in the States, as well as kind of the lack of standards and practices across the globe in regards to this industry. So when we talk about DigiShares as a platform and utilizing the blockchain to tokenize assets and specifically real estate assets, there are a couple different legal paths. And I always start with this high level question of which jurisdiction are the issuers based in. So the actual people that or team that are facilitating the issuance of the token or the tokenization of the assets. And then subsequently, what are the jurisdictions of the individuals and or entities that could be participating in acquiring the asset? And those two answers are really going to dictate kind of the legal framework and legal path that most people need to consider when they're thinking about tokenizing and utilizing DigiShares and the Ravencoin blockchain and so on and so forth. So within that, assuming that the answer to that question in a hypothetical is you're based in, say, the United States and you're targeting US investors for actually acquiring the assets, the regulatory regime in the United States, for those of you who don't know, is quite strict when it comes to digital assets. And as a result, there is going to be a higher threshold or a higher burden from a compliance standpoint. And on the legal side, there are a couple different avenues for issuing the token. And a lot of times, and again, the SEC being probably the most integral governmental agency in the United States involved in this industry, is very much concerned with consumer protection. And so they're coming at it from the perspective of they want to ensure that anybody offering a digital asset, if that digital asset falls under the definition of a security, then there needs to either be a registration with the SEC or an exemption sought. So when we talk about tokenization of real estate, the easiest to market path is creating a special purpose vehicle in a favorable jurisdiction. Delaware, Wyoming are kind of at the top of that list because of their recognition of smart contract technology, as well as tokenization and so on and so forth. And forming that entity and then actually having the tokenization and describing what the economic rights are within the token are equally as important, because there are anti-fraud provisions of the Securities Act of 1933 that someone going out and digitizing some type of asset, they really want to make sure that they adhere to that. So within that, the most common form is called Regulation D. And a lot of times that categorically limits the issuer to accredited investors. So that means that only accredited investors can typically participate by accessing the token. And really there's that limitation and very much a mirror of the traditional issuances that have happened before the advent of tokenization technology came about. So one of the considerations there is, okay, I have a lot of clients that come to me and they're saying, well, I want to really target retail investors. How do I theoretically do that from a legal compliance standpoint? I'm like, okay, well, we know we have this clear path in this categorization of Reg D and being able to issue it to accredited investors, but going and seeking some of the other exemptions that are out there, probably the two most prevalent when it comes to targeting non-accredited investors are Reg CF, which is called Reg crowdfunding, and then Reg A, which has two different tiers. And the objective underpinning both of those is really not requiring this accredited investor threshold, so that whatever the digital asset is, it can actually be offered to those individuals. I want to pause and just highlight a side caveat that Tron mentioned when you're developing, say, whatever the fee is for creating an NFT on the blockchain. That is not what we're talking about in this context right here. We're talking about seeking an exemption for a token that most likely has some direct economic right, say within the company that is issuing the token. And maybe that company either has one piece of real estate that they're fractionalizing ownership for, or they're having a portfolio of different types of real estate that then the revenue that is generated is provided in terms of dividends to token holders. And again, we can kind of conceptualize this process as identifying the traditional real estate investment model and really streamlining that entire process, and every transactional junction that required, say, a third-party verifier. The blockchain supplants that and really allows for this seamless transition utilizing, say, DigiShares white label technology service, being able to actually tokenize and then realistically be able to get an asset in the hands of a purchaser relatively quickly with not a significant amount of legal hurdles to go through. And that's really the benefit, or underlying, at least one of the underlying benefits of the technology in of itself, is that there's obviously this proof of ownership component to it. And so any purchaser that comes in and acquires that asset from a legal perspective, they're obviously going to have to review all the information for the issuance and what the asset provides in terms of economic rights. And I can probably think of a million different examples that could theoretically represent. Some of the more common ones are equity in the company, or, like I mentioned in the real estate context, a right to dividend distribution based on the profitability of a real estate portfolio. And those considerations as well are really about, okay, are those economic rights rising to the level of what we consider to be an investment contract, or also known as a security under the Securities Act? And so realistically, if I'm in this hypothetical issuing a token in the United States, there's a high probability that I might fall under that category. Now, that doesn't mean that everyone's going to fall under that category, because if we change the hypothetical to say that, okay, this is an offshore entity that's issuing a digital asset to offshore individuals or entities, then that's a wholly separate consideration from a legal perspective, because we're shifting the jurisdiction, which relates back to my initial comment about those two questions. And that's why those who are considering tokenization should also add on those two questions to themselves and be like, okay, realistically, where am I based as an issuer? Am I going to seek some type of offshore entity for potential tax benefits, or to theoretically geofence certain jurisdictions with high regulatory burdens, such as the US or the UK? And also on top of that, where are all the investors or participants or token holders that I'm targeting? And so that kind of creates this full loop where if I want to say go and offer the token in a jurisdiction that doesn't have nearly as high as a regulatory burden as, say, the United States, we'll use the Philippines as an example, that I am going to need to potentially qualify for, say, an exemption in the United States if I, as the issuer, am based in the United States. But if I shift that and I have some ownership components that are more foreign based and really cutting off the participant perspective within the United States or these other jurisdictions, then I actually have a different path that has different legal considerations and different disclosure requirements. And again, these are all questions that are fleshed out throughout the process of evaluating, okay, what is the token going to represent? Where is it going to be offered? And so on and so forth. And so realistically, the great thing about having this technology or some type of service like DigiShares is providing is that your technological development component is streamlined extensively, which lends support to the ability to also be able to streamline the legality component of offering a token that potentially represents some type of ownership. And again, when we scale back and think about, okay, there are so many different avenues, and talking about maybe the more retail investor focused exemptions in the United States, for example, if you have an offering that you want to go out and raise tier 2 of Reg A plus, you have to get an approval, like an actual stamp of approval. It's an application process with the SEC. Versus seeking Reg D exemption, you're actually just filing a document within their database and making sure that all your documents are up to par in regards to the compliance. So it's not necessarily a stamp of approval in the traditional exemption context. And so all of these considerations definitely should go into not only obviously the conversations that you're having with third-party providers, but also if there are broker-dealers that are involved. And then all that kind of boils down to even thinking about, okay, what is the token representing and what type of entity am I actually structuring? Because I referenced the special purpose vehicle in the beginning as a very easy way to get to market in terms of representation of ownership, but there are many different ways of going about it as well. You can tokenize funds, for example. You can actually have a representation of ownership within, say, like a real estate fund or even something akin to a REIT. and then extrapolate that concept and talk about, okay, well, what about an investment fund? And also, what are the assets that I'm actually investing in as a company? And do I have the ability to tokenize? Theoretically, you do. You just need to make sure that if there's any type of registration requirement, that you're having an attorney or somebody on your team file those documents, as well as making sure that all of the language that is disclosed to individuals or prospective purchasers, that that's up to par with the requirements. And again, this can extrapolate to the nth degree in that we have offerings that are utilizing platforms and are being offered all over the world, but it's very much a consideration of jurisdiction by jurisdiction. And so there are exemptions in certain jurisdictions that might have stricter standards, such as the US, while simultaneously you might have a participant in another jurisdiction that, say, satisfies Reg S if you're issuing the token out of the United States, and they actually just have to satisfy their own local jurisdiction requirements, whatever those are in terms of sophistication of the investor or qualification of the investor. And again, it gets really diverse because a lot of different jurisdictions have much different considerations when it comes to accreditation status and so on and so forth. And as a result, these are all very important legal questions that anybody considering tokenizing an actual security should very much really consider. And the last point I'll actually make, which is another side caveat, is when talking about the ability to, say, create an NFT, the real difference there is the lack of fractionalization in, say, a traditional NFT. There are now NFTs that you can fractionalize and tokens that are latched on via smart contract and so on and so forth. And those are a little bit more ambiguous from a legal perspective. But at a high level, we can confidently say that traditional NFTs, to a certain extent, are most likely not going to fall under that securities definition. And so there's a much more straightforward path and less regulatory burden from the perspective of, say, generating an NFT on a platform versus a token. But all that is to say is that you're also not going to have the same economic interest right representation from a corporate perspective that you would if you were digitizing the asset in the token context. And so those are very different parallels and purposes that should be taken into consideration in that regard. And then I guess with the last couple of minutes that I have, I'll be sure to kind of ask or answer any questions that have come up. I know that some of them were addressed, but more than happy to answer any of them.
Yeah, I think there are some good questions for you. We can take the first one from Nitin. Can the same asset be sold to accredited and retail investors through different types of tokens?
Yes, but also with the caveat that it's all about the exemption that you're seeking. So on the one hand, I could have a Reg D offering with a token that is literally a representation of ownership in my company, and that token is offered to accredited investors. And simultaneously, I could have a Reg crowdfunding offering going on that has a different type of token that is potentially very similar, but needs to be identifiably different to the extent that an investor on either side of those offerings wouldn't have. They basically, if they could get confused over what it is they're actually purchasing, then you might have a potential issue. And so you really want to make sure that those parallels are very well defined in the offering documents. And also with Reg CF, a lot of times you're targeting, obviously, those retail investors. And as a result, there's some additional disclosures that you want to incorporate into that. But for all intents and purposes, for sure, yes.
Very nice. And one more. Is Reg S automatic when you file Reg D paperwork?
So there's no requirement to actually file with the SEC for Reg S. You just have to satisfy the exemption itself. And there are two main components: are making sure that it's an offshore transaction. Mm-hmm. So typically from somebody who's in a foreign country. And then that person is representing and warranting to you as the issuer that they are adhering to whatever their accreditation or sophistication standards are in their jurisdiction. And it's a little bit different from verifying accredited investors in the United States, because it's not like you're sitting there going, okay, send me bank statements, send me all the proof that you have accreditation status. It's a little different from jurisdiction to jurisdiction, but from a high level perspective, a lot of them are very much based on this notion that they're going to represent and warrant to you that they satisfy their local jurisdiction rules. And a lot of that is satisfied through the disclosures that you would provide in your offering documents.
Very good. Then we have one from Cameron. How can we get in touch with you? My team and I just set up Rec D506C and want more information.
Yeah, for sure. So I mean, I'm more than happy to share my email address with everybody. And I mean, my firm is called Bull Blockchain Law. If you just Google us, you'll find us. But my name's Andrew Bull, founder of the firm. My ame is andrew@bullblockchainlaw.com. So relatively easy.
Relatively straightforward, yes. Do you have a white label platform from another company with no ATS? Where do you start with being legal in the USA for real estate tokenization?
Okay, so they have a white label platform from another country, no ATS. Yes, so I'm actually not going to weigh in on that just because there are a lot of moving parts to that question, and there's a ton of different considerations depending on what exactly the white label is offering. I mean, from a high level perspective, there's broker-dealer considerations, and potentially, obviously, this person's thought about whether they need an ATS, but those are all very contingent on what exactly the services are. I will say, as a side note, a lot of times it's all about the control over the transactions that are being facilitated. So if you find yourself as a company facilitating third-party transactions on behalf of two different parties, you're most likely going to need that licensing.
Okay, questions are just coming in, and we have 30 seconds left. So we'll take one, and then hopefully we can answer the rest in the Q&A later. So do you have to be on platform to offer Rec CF, or can I create my own landing page and connect to DigiShares?
So yeah, in the United States, you do have to offer through a FINRA approved third-party portal. And the requirement there is basically FINRA regulates those third-party portals. And so they have onboarding requirements. There are exemptions to that, but they're very, very razor thin. So for all intents and purposes, yes.